Hello students, your topic for today is Chapter 5A Rajasthan Rent Control Act 2001. So this chapter deals with the appointment of rent authority, a tenancy agreement, and period of tenancy. So section 22A is about the appointment of rent authority. So the state government may appoint by notification in the official gazette officers of the Rajasthan Administrative Service not below the rank of sub-divisional officer as the rent authority for the jurisdictional areas of every rent tribunal to perform functions and exercise powers in matters that are specified under section 22B, 22D, 22E, 22G, 23, and 24 of this Act. An appeal that is against the order of the rent authority has to lie to the rent tribunal within 60 days from the date of order. Then section 22B is the tenancy agreement. So notwithstanding anything that is contained in this act or any other law for the time being in force, no person shall after the commencement of the Rajasthan Rent Control Act 2017 let or take on rent any premises except by an agreement in writing, and the particulars of such agreement shall be communicated to the rent tribunal by the landlord and the tenant jointly in the form specified in Schedule D. Where any relation of to a tenancy created before the commencement of Rajasthan Rent Control Act 2017, uh, an agreement in writing having already been entered into, the particulars thereof shall be communicated to the rent authority in the form specified in Schedule D. No agreement in writing was entered onto the landlord, and the tenant shall enter into an agreement in writing with regard to that tenancy and communicate the particulars thereof to the rent specified in Schedule D. Then every agreement that is referred to in subsection 1 shall be executed before the commencement of tenancy, and the agreement that is required to be executed under clause B of subsection 2 shall be executed within a period of 1 year from the date of commencement of Rajasthan Rent Control Act 2017. The rent authority, after receiving such information about tenancy agreement, shall make entry of particulars of the agreement in register mentioned for that purpose, containing particulars as per Schedule D, and provide a registration number to the parties. The information that is provided as per subsections 1 and 2 shall be taken as evidence of the facts relating to the tenancy and matters that are connected therewith, and in its absence, any statement in the agreement inconsistent with the details filed as per Schedule D shall not be received as evidence of the facts before the rent tribunal or the appellate rent tribunal, as the case may be. The rent authority shall upload the details of all the tenancies along with the registration number provided under subsection 4 in form and manner prescribed on its website within 15 days of the allotment of the registration number. Now, section 22C is the period of tenancy. So, all the tenancies that are entered into after the commencement of Rajasthan Rent Control Act 2017 shall be for the period as agreed within the landlord and the tenant and as specified in the tenancy agreement. The tenant may approach the landlord for renewal or extension of the tenancy within the period agreed to in the tenancy agreement period to the end of tenancy period, and if they agreeable to, the landlord may enter into a new tenancy agreement with the landlord on mutually agreed terms and conditions. If the tenancy for a fixed term ends and has not been renewed, or premises have not been vacated by the tenant at the end of such tenancy, then the tenancy shall be deemed to be renewed on a month-to-month basis on the same terms and conditions as per in the expired tenancy agreement for a maximum period of 6 months, and shall thereafter be deemed to have expired unless renewed by the landlord by the agreement within the tenant in writing. Then chapter 5B is talking about the revision of rent in certain circumstances, security deposit, depositing of rent in certain circumstances, etc. Section 22D deals with the revision of rent in certain circumstances. So where the landlord, after the commencement of tenancy and in agreement with the tenant, has incurred expenditure on account of improvement, addition, or structural alteration in the premises occupied by the tenant, which does not include repairs necessary necessary to the carried out, then the landlord may increase the rent of premises by an amount as agreed between the landlord and the tenant prior to the commencement of the work, and such increase in rent shall become effective from 1 month after the completion of the work, where after the rent of a premises has been agreed or fixed, there has been a decrease or diminution or distortion or accommodation or housing services in the premises, then the tenant may claim a reduction in the rent. The landlord may either restore the premises and the housing services as the commencement of the tenancy, or agree for a reduction in rent. In case of conflict, the landlord or tenant may approach the rent authority by filing petition before the rent authority, and the authority shall try to resolve the conflict and to arrive at amicable settlement between the landlord and tenant. And if no such settlement is arrived at between the parties, he may pass appropriate orders on basis of material brought on record and by hearing both the parties. Section 22E is the rent authority to fix revised rent in circumstances specified in Section 22D. Then section 22F is the security deposit. So save as the agreement to the contrary, it shall be lawful for the landlord to charge a security deposit equal to 1 month rent. The security deposit shall be refunded to the tenant within 1 month after vacation of the premises, after making due deduction of any liability to the tenant. Wherever the security deposit is not refunded to the tenant within the period that is specified in subsection 2, the tenant may file an application before the rent authority for directing the landlord to refund the security deposit. Section 22G is the depositing of rent with the rent authority in certain circumstances. So, where the landlord does not accept any rent tendered by the tenant in the matter specified in Section 5, or refuses to give a receipt, the tenant may deposit the same periodically in time with the rent authority. Wherever, in any case, there is a bona fide doubt about the person or persons to whom the rent is payable, the tenant may deposit such rent with the rent authority. On deposit of the rent authority shall investigate the case and pass an order based on facts of the case. The amount of rent that is deposited under this section shall be accounted for in such manner as may be prescribed, and shall be kept in personal deposit account, and shall be operated for payment to the landlord or other lawful claimant in manner as may be prescribed. The received by the landlord of rent deposited under subsection 1 and subsection 2, as the case may be, shall be operate as admission to the correctness of rent and other facts stated by the tenant while depositing the same. That's all. Thank you.